Sir, please introduce yourself, state your name and DOC number for the record.
That's the chair.
What's your DOC number?
104970.
All right, Lester, my name's Brennan Kelsey. Along with me is Mr. Pearl Wise and Mr. Alvin Roche. We'll have a parole interview, ask you some questions. You can respond. At the end, you can make a statement. We'll take a vote. You understand the process? You understand how this is going to work?
Oh, yes, sir.
All right, Lester Chairs, DOC number 104970. You're a third class offender. Parole eligibility date 5/19/2003. Good time date 3/27/21/12. Full term date 7/6/2238. 258 years. Armed robbery, crimes, aggravated crimes against nature, armed robbery, first degree murder. That sound correct?
Yes, sir.
Okay, would you answer Ms. Pearl Hines, please?
How are you feeling today, sir?
I'm doing so.
What's the matter?
But not really, man. I'm just anxious, you know.
Oh, okay. Well, that's explained. That I mean, that's understandable. Call out for the record, sir. How long you have served?
Call out who?
How long have you been in jail?
Oh, about maybe about 3 or 4 years.
Okay. Well, sir, the record shows that you've been in jail since 2004.
No. I mean, I got out. It went back. Yeah.
I'm sorry, 1984. I'm so sorry. 1984. I'm sorry. 1984. Yeah. Yeah, and it's 2020 now.
Yes, ma'am.
All right. So what do you do every day?
Well, mostly, you know, we talking with my neighbors and trying to see what else I can.
Mr. Wise, this is Warren Benoit. He's been in a cell just about he has been in a cell his entire time here. I think he came here the first time in '73, and he got out for just a little while and come back in '84. But he's always done all of his time in a cell.
Okay,
He's never wanted to leave a single man cell.
Okay. All right then. Well, that's all I have. Chairman.
All right, Mr. Roche.
Mr. Chairman, I have no questions.
All right, so Mr. Chair, as you've been, you like to stay where you are, huh? In your own cell? You just kind of like to stay there and hang out?
Just, I'd rather stay there, you know, than go somewhere else.
I got it.
Mm-hmm.
All right, makes sense. All right, Mr. Randy Meyer.
Yes, sir. There I come. Randy Myers, Assistant DA Jefferson. My concern with Mr. Chairs was the lack of programming, no sex offender treatment, no anger management. So for those reasons, and the violent nature, we would be opposed.
Okay.
All right, thank you. Mr. Chairs, you would like to make a statement on your behalf? You'd like to make a comment for yourself?
Well, you know, you gotta think about a few words, you know. And for talking about my parole, you know. I sure appreciate, you know, that y'all I got granted. I got granted, you know, have this parole hearing, you know.
Mm-hmm.
I've been gone so long, you know. So many people in my family have passed away, you know.
Mm-hmm.
But I never gave, you know, no problem to that. It's for somebody doing something about it. And I know I can't do but one thing about it. I had to pay, you know, pay for the people who
All right. All right, thank you. Is the panel prepared to vote?
Yes, I'm ready.
Ms. Pearl?
Mr. Lester, if you are serious about what you said about you want to go home, you want to be with your family, then I want you to give some serious thought to getting out of the cell and getting where you can get some programs. You can take some classes, you can learn some new things and prepare yourself for the outside. Just think about it. Just think about it. And I'm sure you know I let the correctional officer know that you want to get moved from that cell. Just think about it. But today, my vote is to deny your parole because you haven't had any classes. You've lost 330 days of good time. I said lack of programs and your violent history. That is my vote, sir. But I do strongly encourage you to think about what I said.
All right, Mr. Roche?
Mr. Chairs, you're simply not ready to be released. You need programming, you need sex offender treatment. You need, as Ms. Wise said, to get out that cell and try to, at the age of 67 years old, try to enhance your knowledge so one day maybe you can be released and rejoin society. But today, simply because you're not ready, my vote is to deny your request.
All right, you have 2 votes to deny. Also going to vote to deny your request. You need programs. You have law enforcement opposition, victim opposition. You have a poor institutional record. So you have 3 votes to deny today. Your parole's been denied. Good luck to you. And it is 2:32, Thursday, December the 10th. It still is. We will adjourn from LSP. Thank
Well, he might be the definition of institutionalized. I don't think we've ever heard that. The warden saying he hasn't left his cell. I mean, he was locked up. What did they say? We actually will go over the information because it's the crime that he committed plays out almost like a comedy. And when I say that, I mean in the events that things happen. So let's go over that. On March 9th, 1983, at approximately 2:15 a.m., a man later identified as Cheers entered a convenience store and asked for a pack of smokes. The cashier obtained the cigs, but when she went to hand them to Cheers, she realized he had a pistol pointed at her. The cashier was ordered to hand over all the money in the cash register, which she did. She was then forced into the storage room. 10 minutes later, and I don't know why he didn't leave, right? So it's 10 minutes later, a delivery man, Melvin, enters the store with the daily newspapers. After placing the newspapers in the paper rack and performing other routine tasks, Bottomheimer started out of the store when Cheers, pistol in hand, came out of the storage room and was ordered to the rear of the store and told to lie on the floor face down. So now he has 2 people. Shortly thereafter, 2 security officers employed by Oshner Hospital entered the store. They were ordered at gunpoint to lie next to Bottomheimer. Cheers then confiscated the coin apron and a 2-way radio from each of the security officers. Now he has 4 people in the store. What's not done? This is why, I mean, it's just bizarre. He already got everything. What is he doing? Then another customer enters the store and was told to lie face down with the others. So I don't know. He could have just taken, the cash from the register and left, but no, now he has 5 people lying down on the floor of the store. Cheers next ordered everyone but the cashier outside the store and into the security vehicle. Sanders and Cheers' command drove the truck a few blocks before Cheers left the vehicle and fled on foot, taking with him money from the store and from Bodenheimer's coin apron and the 2 radios. When police, after what I saw at this hearing, it's kind of what I expected, but man, when police arrived at the store, the cashier gave statements and description of the gunman. Cheers later became a suspect as a result of the investigation by Detective Susan Miller on another armed robbery case. She forwarded the photograph of Cheers to the detective who was investigating the convenience store robbery. Police prepared a photographic lineup which was displayed separately, and the cashiers and Sanders and Newman each positively identified Cheers from the photo array in each firm. Cheers contends that the photographs shown in the cashier and the 2 security personnel were mugshots and were suggestive of prior criminal activity, thereby having prejudicial effect first on the victims and later on the members of the jury. The photographs were taken for police use, and they do have lettering and identification numbers on the front side of the photo shown. Well, I mean, if I hear that, it's not a terrible argument. A conviction based on eyewitness. Also, there was an appeal on here which I thought could have stood, but the judge did not agree, and that was that the DA in closing arguments said that he did not testify on his own behalf to the jury, which you can't do. You can't say that. You have a right to remain silent, and the DA included that verbiage in his closing argument, but the judge in this case, or the appeal judge in this case, didn't think that violated his constitutional rights, and I disagree. I think that's pretty clear and simple that you cannot say that, but they didn't care. They just didn't. I think in Louisiana they kind of did what they want so much at a time. They just didn't want to do another retrial. The victim testified that although Cheers wore a hooded sweatshirt, the lighting in the store was good enough to view face-to-face, close proximity. Thus, there was independent basis for each court identifications. I mean, plus you got 5 people could identify him. What's interesting here is that we don't have information on the crime against nature, which is what he needed the SA treatment for, and I'm guessing, if I had to guess, it's probably that his initial crime that he was in for the crime against nature, he got 10 years, like how the warden had mentioned. And well, here's something interesting. So this is a different document that shows here that he was charged with 2 counts of armed robbery and 1 count of aggravated crime against nature that all arose out of the incident which happened on March 9, 1983 at the convenience store. So, they don't go into any of the details of the crime against nature in this report, but I guess I think it's safe to assume that the reason he was in that storage room for 10 minutes why another person came out is because he was committing that crime. He was, there you have it. And they gave him, what was it, 258-year sentence. So you might ask, well, how come if he has a 258-year sentence, how come he has a chance of parole? And that's because of Act 122, legislation that was pushed and lobbied hard created and lobbied by the Parole Project, which made any offender, or most offenders, eligible for parole if they are over the age of 40 and had served more than 20 years. So that throws out his 258-year sentence. I think, and it makes anyone except for those who commit homicide eligible for parole, and that's why he has an opportunity for parole. So They passed legislation because it means that more money goes into the parole board's project, the parole project pockets, because funding was part of this legislation that would fund the moving of inmates out of the DOC, and the whole thing is just a scheme, in my opinion. And the side problem of it is that you have inmates like the ones we just saw who are up for parole who shouldn't be, and we have victims who are re-victimized having to show up to parole hearings. There are use cases where it is a beautiful thing. If you're serving a life sentence because you had 3 possession charges over 10 years, and yes, Act 122 is wonderful. But so many parole hearings we have to watch should not be up for parole, in my opinion. With that, I'll let you go.